You may call your next witness.
Your Honor, now might be, I think we're going to get into.
Well, we're waiting for lunch to arrive for the jury, so we're going to keep going.
Okay. Bear with me just a second.
All right?
While Mr. Yalamanchili is tracking down that witness, I did just get a text from another witness that the state could put up, and I'm comfortable doing that while he tries to run that person down.
That's perfectly fine with the court. I mean, it's your case.
John Newton?
Could you get John Newton? Thank you.
Sir, if you could raise your right hand, do you swear or affirm that your testimony in the matter pending before the court should be the truth, the whole truth, and nothing but the truth, so help you God? I do. Okay, you can have a seat. If you could state your name and spell it for our court reporter, please.
My name is John Newton, John Newton.
And Mr. Newton, going to refer you back to 2001. Where were you employed at that time, sir?
I worked for the Athens-Clarke County Police Department.
How long did you work for the Athens-Clarke County Police Department?
12 years.
Okay. And during that time, were you a post-certified peace officer in the state of Georgia?
Yes, sir.
And what is that? What does post-certification mean?
Post is the standards council that creates the standards for police officers for what it means to be, I guess, to be an accredited police officer in good standing.
Basically, a sworn officer, is that fair to say?
Yes, sir.
And did you work anywhere else in law enforcement after Athens-Clarke County?
After? No, sir.
Okay. Back in 2001, did you help with other officers in the investigation into the sexual assault and murder of Tara Baker at 160 Fawn Drive?
Yes, sir.
And are you familiar with that, where that address is?
I'm familiar with the general area. I don't think I could drive you to right where it is, but right off of Lexington Road near the church and that neighborhood back in there.
Is that in Clark County?
Yes, sir.
Now, I know you had a lot of involvement in that case, but I want to focus on just a few very specific things. In the days immediately following Ms. Baker's death, did you have an opportunity to collect head hair samples from certain persons in Tara's orbit?
Yes, sir.
Okay, did that include known hair samples of her roommates, Ashley Peavy and Valerie Lang?
I believe so, but off the top of my head, I couldn't tell you. Like, I would have to look at my report.
Would that help refresh your recollection?
Yes, sir. That would be wonderful.
May I approach the witness, Your Honor?
You may.
Thank you. Yes, sir.
Actually, the same question. Did that include collecting known head hairs from her roommates, Ashley Peavy and Valerie Hall?
Yes, sir.
Did it also include collecting head hairs from Chris Melton?
Yes, sir.
Can I approach the witness, Your
You
Honor?
may.
Then I'm going to hand you what I marked as states 108, 109, and 110. Do you recognize those items, sir?
I recognize what they are. I can't say off the top of my head,
Sure.
This is it, but yes, this is my handwriting on these, and these would be evidence bags.
And do you take your time to review those items in their entirety. On each of those items, do you see your name or initials on a piece of evidence tape?
Yes, sir. My initial is on, or my signature and or my initial and my handwriting is on each of these.
And what do they appear to be?
One is the known head hair of Ashley Peavy.
Is that 108? With the evidence stickers?
Yes, sir.
States 109, what is that?
Known head hair of Valerie Lang
And then 110?
is the known head hair of Chris Melton.
And again, just to be clear, when you collected each of those items, 108, 109, 110, what would you have then done with them?
Put them in the bag, sealed them, put my initials on them, and placed in an evidence locker.
Okay. And from that point on, would you have any idea what may have happened to those pieces of evidence?
I would have an idea, but I wouldn't do anything with them.
Okay.
I mean, I put them in there for the purpose of, further examination, but I wouldn't be involved in that.
I would move to tender states 108 through 110 at this time.
Any objection?
Yes, ma'am. Lack of foundation, one, we don't, excuse me. First, lack of foundation. We don't know if anything is in the bag. I would ask that the witness is allowed to identify what's in the bag. Two, if the bag is what the state seeks to introduce with the writing of whose name it is, I would object to relevance, as the bag is irrelevant to any issue in this case. It's what's inside of the envelopes. So those are my two objections, Your Honor.
Thank you, Mr. Cruz. Mr. Bolden, you care to respond before I make a ruling?
No, Your Honor.
All right. The foundation has been laid for the purpose of admission of evidence. I'm going to admit them over objection.
I'll take those back from you. And then at some point later, in your participation, that's hard to say, in this investigation, did you have the opportunity to once again meet with Chris Melton in an attempt to obtain his pubic hair samples?
Yes, sir.
Okay. And as you sit here today, 25 years later, do you remember exactly when that might have been?
Not without looking at my report, sir.
May I approach again, Your Honor?
You may.
Take a minute and see if that helps refresh your recollection.
Yes, sir.
Having had the chance to review what I just answered, does that help refresh your recollection as to when you would have attempted, or when you would have collected known pubic hairs of Chris Melton?
Yes, sir. It was on February 27th of 2001.
Where did that take place?
This is the GBI office in Gainesville.
May I approach, Your Honor?
May.
One last thing. States 111. Actually, take a look at that.
Yes, sir.
And do you recognize that?
Again, I recognize my handwriting and everything that's on it. Right. It's a evidence bag with my handwriting and my initials and the date of February 27th, 2001.
Does it have markings that would indicate what?
Oh, I'm sorry. It's the known pubic hair of Chris Melton.
I moved to tender states 111.
Any objection, Mr. Cruz?
Yes, ma'am. Lack of foundation to the item that's in the bag, and Rule 401 is relevant. The state is intending to just introduce the bag itself.
Mr. Bolden, any response?
Your Honor, it is relevant. Mr. Cruz has made chain of custody an issue in this case, so we're attempting to introduce the bag. The state will then go on to introduce what the contents of the bag, and so this is the necessary first step. So I think it is relevant.
I'm going to admit it over objection.
Yes, And again, kind of like before, Mr. Newton, when you collected those, how would you have them packaged them in States Exhibit 111?
Right. We would take the evidence, put it in the bag, seal the bag, and put it in an evidence locker.
And understanding, as before, you might have some idea about what happens from that point forward. Did you have any further involvement with States Exhibit 111?
I did not.
Sir, those are all the questions that I have at this time. Defense counsel may have some questions.
Mr. Cruz, cross-examination.
Good afternoon, Mr. Newton.
Good afternoon, Mr. Cruz.
I did not know you would be testifying this fast, so forgive me.
I did not know that either.
I have a couple of questions for you. Is it okay?
Yes, sir.
Thank you. On January 21st, 2001, do you recall capturing pictures of Mr. Chris Melton's hands?
I apologize, Mr. Cruz, but I do not. I probably wrote a report, and if I could look at the report, I could tell you. But this long afterwards, I can't say that I have an independent recollection of what happened.
Yes, sir. That is fair. So what I would do, I'm going to provide you a copy of the report as well as the photographs to give you a
Yes, sir.
look over them. Is that okay?
That's great, sir. Thank you.
Perfect.
I haven't seen them, Your Honor. Mr. Cruz.
Yes, sir.
Thank you. Yes, sir.
Do you recognize those photographs?
I'm not sure the appropriate way to answer this. I recognize what they're photographs of and what this says. Do you by any chance have a report that I wrote with this?
I may. Court's indulgence.
But I recognize the photo log and what's listed here, and what the pictures are of.
What are those pictures of?
These are pictures of hands along with a ruler showing injuries to a hand,
And can you?
to fingers, back of the hand, those sort of things.
That's fair. And do you recognize that property sheet?
This is my handwriting on this property sheet, and it's a property sheet that I filled out on January 21st, 2001.
Okay. And it states photographs of Chris Melton's hands?
The photo log states that, and then the sheet that says it, and then the evidence sheet says there are pictures of Chris Melton. But you're right, the photo log shows what each specific photo was of.
Sure. And that's the report I was looking for. I realized I gave it to you. So yes, that is the cover sheet, and the following photos would be what was included in the discovery.
Yes, sir.
But that's that. Do those photos appear to be a fair and accurate depiction of the photographs that you took of Mr. Melton's hands?
Yes, sir.
Okay. Do those photographs appear to be altered in any way?
They do not appear to be altered to me, no, sir.
Let the record reflect that I am marking Detective Newton's property and evidence record sheet of pictures of Chris Melton as defense exhibit 28.
That's what I have. I think that's right, Mr. Cruz.
Yes, ma'am. Thank you, Your Honor. And let the record reflect that I am marking 14 photographs of Chris Melton's hands as defense exhibit 29. And Detective Newton, I have a few more questions for you in regards to the property form. I want to ensure I lay the proper foundation for that form.
Yes, sir. Yes, sir. Thank you.
Now, you testified that you recognize the document. Has that document, does it appear to have been altered in any way?
No, sir. It does not appear to have been altered.
And is it a fair and accurate, or is the document a fair and accurate copy of the document as you would remember it?
Yes, sir.
Okay, thank you. Your Honor, I would move to admit Defense Exhibit 28 and 29 into evidence.
Any objection? They are admitted.
I would ask for permission to publish Defense Exhibit 29 to the jury.
Granted.
And Detective Newton, you would agree that those photographs were taken 2 days after Ms. Baker's death?
Okay. I would agree they're taken on that date. I apologize. I don't remember the exact date of the incident, but on the date that's listed there, I would agree, yes, sir.
Okay, January.
And being that that's probably 2 days, an answer yes, but I apologize. I didn't review
That's fine.
very few things before coming in here.
That's on me. So I'll say this.
But the date on that would be the date that all that would have taken place. Yes, sir.
That is January 21st, 2001.
Yes, sir.
Thank you. Do you recall obtaining phone records from Miss Tara Baker?
I don't recall that specifically, but I would be surprised, if that's not something we did.
Would seeing and for purposes of the record, it is a copy of Detective Newton's affidavit in reference to phone records, court order for the phone number 706-316-9760.
Your Honor, I would again ask that Mr. Cruz show me something before he tries to hand it to a witness.
That's correct.
I apologize. I'm just moving too fast. I'm sorry. Is it okay if I approach?
Yes, sir. Thank you.
And after you've had opportunity to review those records, just look up. I'm going to have a couple of questions for you about those records.
Yes, sir.
All right. Have you had opportunity to look at the documents provided to you?
Yes, sir.
Okay. What would you describe those documents as?
Phone records for the phone number 706-316-9760. So they show phone calls, time of duration, whether it was answered or not, carriers involved in some instances, and it has dates and times of the calls.
Yes, sir. And Would you have any reason to agree that those are Ms. Tara Baker phone records?
That's certainly what they appear to be.
And may I approach you?
Yes, sir. Thank you, sir.
Let the record reflect that I provided you with a pen and a sheet of paper. Is that correct?
Yes, sir. Blank piece of paper with lines on it, blue
Okay.
pen.
And a pen. You're actually going to need these two, so let me give you these.
Yes, sir.
We've already agreed that those records that you have are Ms. Baker's records, correct?
Yes, sir.
Would you mind writing on that sheet of paper Ms. Baker's phone number based on those records?
I would object. He is asking the witness to testify about an item that is not in evidence.
Any response, Mr. Cruz, to the objection?
No, ma'am. This witness has personal knowledge of those items, so I would just ask that I have no response other than this witness has personal knowledge of.
I mean, with regard to the evidentiary objection, Mr. Bolton Maine, he is correct. I'm going to sustain the objection.
Yes, ma'am. Court's indulgence.
Yes, sir.
Let the record reflect that I am marking the items identified. I know I've been calling you Mr. Newton. It just feels so natural to call you Detective Newton. Can I call you Detective Newton?
Sure.
Okay. The items, let the record reflect that I am marking as Defense Exhibit 29.
We've done 29. I think you're on 30.
30.
I think that's right. Do you have that, Ms. Satterfield? Thank you. Yes, number 30.
Let the record reflect that the items that Detective John Newton has identified as Ms. Baker's phone records have been marked as Defense Exhibit 30, and that's in regards to number 706-316-9760. Let the record reflect that I am showing the state what has been marked as number, Tara Baker phone records, Defense Exhibit 30. And did these phone records appear to be altered in any way?
No, sir, they do not.
And is this a fair and accurate depiction of the phone records as you remember seeing them 20 plus years ago?
It's a fair and accurate representation of what we would receive as phone numbers.
Yes.
Again, I don't know that I have any independent recollection, but to the best of my knowledge and ability, those would be the phone records.
Yes, sir. Thank you. Your Honor, I would move to admit into evidence Defense Exhibit 30.
Any objection?
I don't think that's a proper foundation for the admission of business records. So I do object to Mr. Cruz attempting to tender those records through this witness.
All right, Mr. Cruz, any objection before I make a ruling?
Any
Any response before I make a ruling about the objection?
Sure. So Detective Newton obtained these records via a court order. So I do believe there's, to respond to their objection, he received these records via a court order, Your Honor.
I don't think that overcomes, though, the objection that the state has produced, which is that it's not a proper way to introduce business records. So I'm going to sustain the objection.
Yes, ma'am. Court's indulgence. May we take a 5-minute break, Your Honor?
Well, I think this would, yes, we can. The answer is yes, but it may be more than 5 minutes. So can I see counsel at the bench about timing issues? that person outside?
Mr. Newton is outside.
Newton. All right, you'll bring him in.
Mr. Newton? Your Honor, if we could address scheduling for the afternoon, just really quickly,
Okay.
Judge.
Hang on 1 second. Mr. Newton, if you'll have a seat back at the witness stand. Thank you, sir. All right, go ahead.
And, Your Honor, I'll preface this by saying, first, I apologize because I think that, we try to make reasonable estimations of how long each witness will take. And so we have Mr. Newton, we have Ms. Brown from the Clark County Sheriff's Office, we have Annie Kistler-Rao from the GBI Crime Lab, and then we have David Griffith, who is a longtime crime analyst at ACC PD. But that's all of the witnesses we have lined up for the remainder of today. We thought that was going to get us to the end of the day. I don't know that it will get us all the way to the end of the day. However, as we stated before, we're ready to proceed whenever we conclude with our fact witnesses for the jury with Ms. Lycon's Daubert hearing. But I do apologize, Your Honor. I know we want to use every minute of the jury's time that we can. It's just some of the witnesses this morning went much faster than we anticipated by a significant amount. And so I do apologize, but I would ask that after we conclude Mr. Griffith's testimony, if that could conclude the fact testimony before the jury for the day.
All right, thank you. And I'll respond to that. And Ms. Cruz, do you want to say anything about that announcement?
No, ma'am.
All right, thank you. I mean, that sounds fine. I mean, it is almost 1:45. You may be surprised that we may not be finished until 5. It's not really that much longer. But that's fine. As soon as we're finished with your fact witnesses, we will go into the Daubert hearing. I think that makes sense. All right, anything else before we bring the jury up from the state?
No, Your Honor.
All right, Mr. Cruz, anything before we bring the jury out?
No, ma'am.
All right, thank you. You may bring the jury out. Everyone, you may be seated. Thank you. Mr. Cruz, you have the floor. We're back on the record.
Sure, and I think before we broke, the state had an objection to the introduction of phone records. I responded and asked for a short recess to look over the law regarding those records. The question I have, I don't think Mr. Bowden was specific with his grounds for objection. If I remember correctly, he said that it was inadequate or inappropriate foundation for business records.
Are you talking about Exhibit 30?
Yes, ma'am.
I've already sustained the objection. If you would like to put some case law on the record, you may, but I've sustained the objection.
Yes, ma'am. Understood. What was the specific objection, just so I could put?
I actually don't remember. I don't write that down. We'd have to go back in the records. If you don't remember and not prepared to present some case law, and I'll let you put case law on the record if you want to. But we need to move forward.
I'll ask this. Can I be heard in regards to his objection? I can't. What I'm asking is, I don't know what the specific legal ground of the objection. I remember he said something that the court agreed to and granted, but in order for me to perfect the record, I would just need to know the specific legal ground. If he's...
Well, I will just say this, counsel. I'm going to ask you to move on with this witness. I already gave both parties the opportunity to respond, and so I'm going to ask you to move on.
Yes, ma'am.
Thank you.
On March 12, 2001, do you recall receiving a message from a female inmate at the Clark County Jail? No.
No, sir, I do not.
Mr. Cruz, if you'll go ahead and show Mr. Bolden what you're going to be working with. Thank you.
Thank you, sir.
And of that document that I provided you, the specific portion to read is paragraph 1, sentence 1.
I object, Your Honor. I don't know that there was a question. I don't know that the witnesses said that there was something that you could, maybe I'm mistaken, but that was.
I think that's right, actually. I think you need to sort of start over and lay whatever foundation you need to with regard to this document.
Yes, ma'am.
All right, go ahead.
On March 12th, do you recall receiving a message from a female inmate at a Clark County jail?
Yes, sir.
Okay. And what did she, she messaged you because she wanted to speak with you about the Tira Baker murder. Is that correct?
Yes, sir.
Okay. And you met with her upon receiving the message from her. Is that correct?
Yes, sir.
And you went to the jail and spoke with her, correct?
Yes, sir.
And she provided you information about who she believed committed Miss Baker's murder. Is that correct? And it would be paragraph 3, if you're looking at the report, sentence 1, 7, and 9.
I do have an objection on the motion that the state previously filed, and.
Can you bring that microphone towards you, Mr.?
403, same as before, Your Honor.
Okay, Mr. Bolden, will you bring that microphone towards you and just repeat your address? I can't really hear you.
Same objection as before. This state's previously filed a motion. I don't think this is relevant under 401. I think it's 403. So I do object to this line of question.
What previously filed motion are you referring to?
The Sadi motion, Your Honor.
Okay. All right. Based on our prior discussion of those kinds of objections, I'm going to send the jury out again. So if you'll go back into the jury room, please don't discuss the case. Thank you. Thank you. All right, y'all may be seated. Mr. Cruz, do you want to make any more of an objection? Let Mr. Cruz respond.
No, Your Honor.
All right, Mr. Cruz.
Okay. To make sure I understand the legal basis for the objection, Mr. Bolden has stated Rule 401, which is relevant, Rule 403. I would ask the specific grounds under 403 that wasn't stated, and the Sadi motion. But if I could get the specific grounds for 403, I could address all three, Your Honor.
All right, Mr. Bolden, specific grounds that you are referring to.
403, Your Honor, I think that this, what I expect the line of questioning that Mr. Cruz intends to ask of the witness would go to potential alternate suspects, alternate perpetrators. The state did file its motion back in October, specifically related to these types of issues. We, at our hearing on January the 21st of this year, Mr. Cruz indicated that the only alternate perpetrator that he intended to identify was Mr. Melton. I think that's been very clear throughout this trial to this point. And so what I suspect he's attempting to do here is to run through every tip or piece of information that the police got relative to anybody over the course of this 25-year investigation, not all of them through this witness. But one, my first point is that the motion that the state filed back in November and that we heard arguments on the 21st, the court granted my motion, granted the state's motion, and except with respect to Mr. Melton. So, you know, to the extent that Mr. Cruz may now be trying to assert that they're alternate perpetrators, that's the whole point of the motion. There has to be evidence proffered to the court before he can ask that type of information in front of the jury, so that the court can make a determination about whether or not any probative value is substantially outweighed, and I will be specific here, confusion of the issues and waste of time. So that is the state's objection.
Thank you. Mr. Cruz.
If I may, Your Honor, I don't quite understand. It was a lot of information, forgive me. I understand he mentioned something about Saudi. Can I get clarity on that, Your Honor? If you understood what Mr. Bowden was mentioning in regards to.
Well, he was just, again, mentioning the hearings that we had about the 412 motion and the rulings.
The rape shield statute?
I'm sorry, not rape shield, Your Honor. The one that I'm specifically referring to, and it was captioned.
That was also on the 21st.
Right, and it was also filed by the state on the same day, which is state's motion in limine to require the defendant to proffer
That's right.
evidence
Okay.
linking other persons to the crime charged. That's the one I'm referring to.
Okay. Go ahead, Mr. Cruz.
So I address each objection piecemeal.
All right. So
in regards to the Rule 401 objection, which is relevant, the relevance of this line of questioning is just simply to show that a individual that's in custody calling law enforcement and saying, hey, I have information on this case, it isn't something unique to this case. Throughout the history of this case, multiple detectives have spoken with individuals in custody, and they'll call and say, hey, I know who committed this crime, and the information would turn out not to be credible. The specific line of questioning that I was going down with Detective Newton was simply to get to the point that this individual offered information to get leniency, which we believe to the jury would be relevant in determining Mr. Cedric Jeffries' testimony. In regards to Rule 403, and I believe he said waste of time, as well as, if you don't mind, Your Honor, I have waste of time. There was one more that he mentioned.
Confusion of the issue.
Confusion of the
Confusion of the issues.
Right.
Okay.
And I'm listening. I'm looking for the motion while you're talking.
Absolutely,
So
that is
go
fine,
on.
Your Honor. Do whatever you need to do. In regards to the waste of time, Your Honor, this evidence directly rebuts the state's evidence. They want to present to the jury Mr. Cedric Jeffries as a unique individual that's in custody, and they would like it to appear to the jury that he's the first in custody individual to come forward with tips on this case. This evidence would rebut that image that the state would portray to the jury if Mr. Jeffries is simply allowed to testify. So it isn't a waste of time, Your Honor. And as far as confusion of the issues, I'm not sure of an issue that could be confused by the Honorable Detective Newton simply stating, yes, someone in custody reached out to me 20-something years ago with information on the case. So that would be my proffer in regards to 403, or my response in regards to 403. In regards to the Saudi motion, just for purposes of the record, I believe the appropriate term for that is third-party perpetrator or alternative suspect theory under Georgia law. That is not the purpose of this evidence. This individual, if I would have been allowed to go down, or if I'm allowed to go down that question with Honorable Detective Newton, the information turned out not to be credible. So it wouldn't implicate the alternative party theory or third-party perpetrator theory.
Okay, so let me just ask you this question, and Mr. Bolden, I'll let you respond, and I'll let Mr. Cruz respond if you wanted to say something. But given what you've just stated, then why is this testimony relevant?
Absolutely, Your Honor. Thank you for the opportunity to respond to that. So the reason this testimony is relevant is because the state intends to bring in an individual by the name of Mr. Cedric Jeffries, who is an individual that is currently serving a 105-month federal prison sentence.
Right.
The state intends to depict to the jury, which is their right because it's their case that they have the opportunity to present, that Mr. Jeffries is a uniquely situated inmate. So when Mr. Jeffries comes in, he'll testify, hey, I'm in custody, so forth and so on. Mr. Faust admitted this to me, and I'm hoping to get a benefit from the state. The reason this is relevant is because we're showing the jury also that Mr. Jeffries is not uniquely situated. Throughout the history of this case, individuals that are incarcerated have called seeking leniency. Excuse me, let me make that clear for the record. Have called law enforcement offering information in order to receive leniency. So that's the relevance of the questioning, Your Honor.
Mr. Cruz, who is the person that this witness went and talked to at the jail in Clark County?
So, Your Honor, I did not intend to get into any names. I don't believe the name of the person is relevant.
So it's not Cedric Jeffries?
No, it is not Cedric Jeffries. This is a separate inmate. And I'll say this, Your Honor, I know sometimes I mince up my words, so I may have explained that the wrong way.
Okay.
So in this instance, what I'm saying is that there is a separate individual from years ago when Detective Newton, the Honorable Detective Newton, was working this case. That individual reached out to Detective Newton and said they had information on this case. Okay, that information turned out not to be credible. And that evidence that we're seeking to admit before the jury is to rebut any type of visual or image or piece of evidence that the state may attempt to introduce Mr. Jeffries as an individual that is uniquely situated. And what I mean by that, Your Honor, is Mr. Jeffries is in custody. He's the only person that's ever come forward as someone in custody saying they have information about this case, and his information is, of course, as the jury would learn, is that Mr. Faust confessed to him. Does that make sense? And if I explained it wrong, Your Honor, please forgive me.
Well, I mean, I understand what you're saying.
Yes, ma'am.
The words that you're saying.
Yes, ma'am.
But I still do not understand how this particular testimony is relevant and how it relates to Mr. Jeffries, other than the statement that you just made, and to let me know if this is what you meant, other than your statement that the state would produce testimony that said the only person in custody that ever reached out was Mr. Jeffries. Is that what you're saying?
No, I probably used too many words.
Okay.
Credibility, Mr. Jeffries' credibility. That's why this evidence.
How does this testimony that you're seeking to elicit impact Mr. Jeffries' credibility at all?
I think that's an excellent question, Your Honor. So what we intend to show is that multiple individuals that were in custody reached out to law enforcement offering information. Throughout the history of this case, all of that information has turned out to be unreliable. And what we're creating for the jury in regards to Mr. Jeffries' credibility is it's consistent with the information that Mr. Jeffries is providing as well.
Okay, thank you.
Yes, ma'am.
Mr. Bolden, anything else, sir?
Not unless the court has any specific questions about the way that I made the objection, I do not.
Okay, I'm making a finding that this information is not relevant.
Yes, ma'am.
And that under 403, it would absolutely lead to confusion of the issues and misleading the jury. I'm not going to allow it. I'm going to ask you to move on.
Yes, ma'am.
Would you bring the jury in, please? All right, you all may be seated. Thank you. Mr. Cruz?
Yes, ma'am. Thank you, Your Honor. Detective Newton, on May 6, 2001, you spoke with Mr. Chris Melton over the phone. Is that correct?
I don't remember doing that, but I'm sure I spoke with him over the phone several times.
Yes, sir. Would seeing your report refresh your recollection in regards to May 6, 2001?
Yes, sir. Thank you.
Thank you. Let the record reflect that I'm showing the Honorable Detective Newton a copy of his May 6, 2001 report to refresh his recollection.
Yes, sir.
Okay. Is your memory refreshed in regards to May 6, 2001?
Yes, sir.
Is it okay if I grab that document?
Yes, sir.
All right, thank you. You don't have to.
Just have it.
Now, this is May 6, 2001, correct?
Yes, sir.
And when you spoke to, well, you understood that Chris Melton, at the time of this investigation, that Chris Melton was Miss Baker's boyfriend.
Yes, sir.
And I believe it was, he described it as he was her borderline fiance. Is that fair to say?
Yes, sir.
Okay. But when you spoke to him on May 6, 2001, and asked him about the Thursday before his death, he didn't have any memory of it. Is that correct?
If I recall, he didn't have a clear memory of it. I think that would be an accurate way to put it, right? There was a lot of confusion in his mind.
Yes, yes, sir. Thank you for that. There was a discussion about going over Chris Melton's finances. Is that correct?
Yes, sir.
Okay. And were you aware that Chris Melton told law enforcement that he had received a check from a place called Nash Plumbing?
He worked at Nash Plumbing, as I recall from that report.
Excellent.
Yes, sir.
And the bank records would have shown whether or not he worked at Nash Plumbing, correct?
That sounds very logical. Yes, sir.
Okay. But Mr. Melton was not comfortable with you going over his finances, was he?
That is correct.
Okay. So based on your time in this investigation, you were never able to confirm whether or not Mr. Melton actually worked for Nash Plumbing.
It's not in that report. I don't recall us doing that, sir.
Thank you. Now, during your conversation with Chris, you asked him for the phone number to Nash Plumbing. Do you recall that?
Yes, sir.
And Chris told you he didn't have the number to Nash Plumbing. Is that correct?
That is correct.
Did you find that odd, considering that he said Nash Plumbing was his employer?
I apologize. I don't remember finding it odd or not finding it
Calls
odd.
for speculation, Your Honor.
Overruled.
I don't remember finding it odd or not finding it odd at the time.
You just had an opinion.
But I asked the question. I would assume I would have expected to get an answer.
Yes, sir. Chris Melton also could not provide an exact address for Nash Plumbing, could he?
That is correct.
The only information he could provide is that it is on 78 near Loganville and that it is a hole in the wall. Is that correct?
That is correct.
Do you ever recall going to Nash Plumbing?
I do not recall, sir.
Thank you so much, Honorable Detective Newton. I do not have any other questions for you.
Thank you.
Any redirect, Mr. Bolden?
Your Honor.
May this witness be excused.
Ask that he be excused.
Mr. Cruz, any objection?
I still have him under subpoena, so I would just ask that, and for the witnesses, please forgive me for not bringing this up earlier. Mr. Yalamachili brought it to my attention. For the witnesses that are under subpoena, just to be respectful of their time, if I could give them 48 hours notice instead of 24 hours notice. Is that okay with the Honorable Court?
I don't have any problem with that. I certainly think that's fair.
Okay, as long as I'm aware, I'll give them 48 hours notice. Thank you.
You're still under subpoena, sir, but you are free to go.
Thank you.